And then the question to Attorney Anita Earls. Our government is based on 3 branches: executive, judicial, and legislative. When legislative matters are before the court, do you have a personal philosophy as to what degree of deference, if any, should be given to laws enacted by our General Assembly?
Good morning. My name is Anita Earls, and I'm running for the North Carolina Supreme Court. I'm very happy to be here this morning. I want to tell you a little bit about myself, and then I'll turn to the question you've asked. I've been a civil rights attorney for 30 years. I became an attorney because I grew up in a mixed-race family. My father's black, my mother's white. And when they met and fell in love in Missouri, it was still illegal in that state for them to be married. It wasn't until I was 7 years old that the U.S. Supreme Court decided Loving versus Virginia and invalidated those laws. But that experience and many others gave me an appreciation of how important it is that we work towards that guarantee that is etched in stone over the U.S. Supreme Court, the guarantee of equal justice under law. So I was very fortunate to be the first one in my family to graduate from college and go to law school and come to North Carolina to work in Charlotte with the Ferguson Stein law firm. So for the first 10 years, I was in private practice. It was a statewide practice, and I handled a wide range of types of cases, from family law, criminal defense, personal injury, but also a very healthy docket of civil rights cases. After that 10 years in private practice, I was appointed to the U.S. Department of Justice as a Deputy Assistant Attorney General in the Civil Rights Division. And there I got the chance to see how civil rights enforcement happens across the country. But I came back to North Carolina because I wanted to be closer to the clients and communities that I was partnering with. So I went to the UNC Center for Civil Rights, again working with Julius Chambers. And then approximately 11 years ago, I left there to create an organization that would allow the young people that we were training in civil rights law at the UNC Center needed a place to practice once they graduated. So we created the Southern Coalition for Social Justice, which is a nonprofit public interest law organization that partners with communities across the state and across the South and doing a wide range of civil rights cases. And it was that experience that really brought home to me how important our state courts are and how important our state constitution is. And that's why I'm running for this office, because I believe in the importance of a fair and impartial court. So I want to tell you 3 things about myself that you might be surprised to hear. The first one is that I have sued Republicans in redistricting cases and sued Democrats in redistricting cases. And in fact, I've been on the same side as Republicans in redistricting cases. And my point there is that throughout my career doing voting rights cases, the touchstone was, does the current system apply with the law, and not the partisan affiliation of who put that system into place. And so most recently, in the 2011 round of redistricting, in our case in Florida, we were defending the plan, sitting at council table with counsel for the Florida Republican Party. Another example, and this, I tell you this so you understand why I believe you can trust me to be a fair and impartial justice. When I was on the North Carolina Board of Elections for 2.5 years, I was appointed by Governor Bev Perdue, but once I swore an oath to uphold our laws, my role was to apply the campaign finance and election laws equally to every party that came before that board. So I was part of the board that unanimously held that our former Governor Mike Easley had violated our campaign finance regulations. We also fined Governor Perdue's campaign. And in local election disputes, we didn't look at whether the Democrat or the Republican won. The question was, did the election comply with our election laws? So I have a demonstrated record of applying the law fairly and equally across the board. Second thing I'll tell you about myself is that when I was doing jury trials in the first 10 years of private practice, I never lost a criminal trial, and for cases that went to the jury, I never won a civil case. Not sure what that means exactly, but that's my record. Third thing I'll tell you that might surprise you is that I do play golf, and I almost always break 100. But let me get to your question. First of all, my personal philosophy actually doesn't matter. What matters is the law. And on the question of deference to the legislature, our courts have been very clear about what that law is. The court can only overturn an act of the General Assembly if it is clear beyond any doubt, it has to be beyond any doubt before the court can overturn a law. So it's a very high level of deference, and it is set by our precedents, and that is the law that I will apply if I'm elected. So again, I'm Anita Earls, and I ask for your support for the North Carolina Supreme Court. Thank you.